of Tennessee is now in session.
Thank you, Mr. Hibner. And on behalf of Judge Stafford and Judge Armstrong, I'm pleased to welcome Mr. Creech and Mr. Darnell to this oral argument, which we are live streaming for the public to view. And it is being recorded so that it'll be available for the public to view at a later date, and of course the parties as well. We will conduct the hearing in the same fashion as if we were all in the courtroom, with each side having 15 minutes to argue and the appellant having to provide a short rebuttal. Unless there are announcements, I'll ask Mr. Hibner to call the case.
Mary Haynes Lancaster Lockett versus Marc Kevin Runyan Sr.
Mr. Creech, you have the floor.
Thank you. I'm Jason Creech of the Washington County Bar for the appellant, and I've reserved 5 minutes for rebuttal. This appeal involves a marital dissolution agreement that arose out of a divorce and its subsequent post-divorce enforcement. We have the issue of the enforcement, the civil contempt issue, the awarding of attorney fees, and on my reply brief, I actually raised the issue of estoppel as well, whether the appellee is even estopped from arguing, given some of his testimony at trial. If you've practiced family law as a practitioner, you know getting agreements and getting these contracts and divorces is more like making sausage than surgery, is a phrase I'm very fond of. It's very difficult sometimes to get warring parties to agree. And so case law indicates that it doesn't have to be Shakespeare. It just has to have offer, acceptance, consideration, and be clear enough to be enforced for it to be a good contract. And that's what we have here. Unfortunately, we also have a situation where somewhere along the way in enforcement, it got sideways. So pretty typical scenario, got a divorce done with an MDA. The appellee began defaulting under the agreement almost immediately. We brought suit for enforcement, had a temporary agreement for him to pay what he could pay in the interim and wait for a later hearing date. About 1 month before that ultimate hearing date, we got what I would consider a rather bizarre motion from the appellee asking the court to decide what he owed from the marital dissolution agreement, but he was using payments that occurred 4 to 5 years prior to the execution of the MDA in asking the court to determine some number. In particular, he had a chart showing payments from October of 2014 through December 2018, when the marital dissolution agreement itself wasn't signed until 229 days from that December 2018 payment. We were scratching our heads a little bit because the MDA in section 9 clearly says husband owes, present tense, the sum of $100,000 to be paid back at $2,500 a month, beginning May 1, 2019, first day of every month, auto draft from his Bank of Tennessee account to a Merrill Lynch account. So I was also confused because the marital dissolution agreement at section 13L said this contract is the entire agreement between the parties, the entire understanding. It supersedes any and all prior agreements between them, and there's no representations or warranties except those expressly set forth herein. And going into the hearing, our office was pretty confident that attorney fees would likely be awarded because of 13G, which says basically if you have to have attorney fees incurred to secure performance, those will be awarded. Now, somewhere in the hearing, again, this got sideways because the court basically allowed the hearing to devolve into a long exercise in parole evidence and got into all the prior dealings of the parties. And you'll see in the record, the court pretty clearly starts critiquing the language of the MDA by telling us what it could have said, should have said, what would have been more clear. And the testimony was somewhat all over the board. For sake of brevity, I'll just tell your honors that the end result of a lot of the testimony was that husband actually had the audacity to claim that he had overpaid and probably was entitled to money back, despite the MDA saying he owed $100,000. He said, I paid 118, 130. His lawyer hopped in and said, no, it was probably 108. whatever the case was, somehow the trial court bit or got confused, I believe, on all this parole evidence that was allowed in. We got a ruling that was so contradictory to the MDA, this appeal promptly was forthcoming. As you know from case law, parole evidence is in our case law to prevent the type of hearing we had. If you have an agreement, it's fully incorporated. We're not supposed to be getting into all these negotiations and contracts and promissory notes and things that existed before a fully incorporated marital dissolution agreement.
And the record will support the fact that you timely objected to this parole evidence.
I believe it was an objection as to relevance. And Mr. Darnell chimed in saying, well, that's something the court can consider as ruling. And then the trial court overruled and then proceeded on with the hearing. But our Tennessee Supreme Court in the recent 2019 case of individual healthcare specialists has reaffirmed Tennessee's position on how we look at contracts and has restated we look at the words of the contract itself, and parole evidence cannot be used to contradict. It may be used in limited circumstances to provide context, but never contradiction. And
Mr. Preach, let me ask you a question, please. Trial court found this to be ambiguous. What was the basis for the ambiguity? I'm just trying to figure out its reasoning in doing that.
In essence, it's a grammar problem. And it boils down to the fact that the marital dissolution agreement says the now ex-husband, the appellee, owes the sum of $100,000, but it says for a personal loan, and it used the singular form. And so when the appellee came into court, he operated under a false pretense that there was one loan of $100,000 that existed way back in time and that he had been paying on that note for years. And that's the ambiguity the court focused on, the fact that it says a loan, which is why he provided this commentary of it could have said what the balance was, it should have said this. But the problem was the parole evidence that the court allowed in to address that supposed ambiguity contradicts the very position of the appellee. For example, the testimony.
But before you go down that road,
Yes,
that was the only reason that the trial court found this to be ambiguous. Is that correct?
as best I can tell.
Okay. It's the only thing the court said, essentially.
Right, certainly the record speaks for itself, but that is the crux of the ambiguity, that it says a personal loan as opposed to a series of personal loans we have satisfied into one round number of $100,000.
So the difference was a loan versus a debt.
Correct.
Essentially. Okay.
That's correct.
All right. Thank you.
And the reason I bring that up is because the actual testimony of the appellee, if you go through the record, is that there was a $75,000 note during their marriage and it ran at 10%. There was a $20,000 loan. There was another $20,000 loan. And then there was a fourth loan of $92,572. How they arrived at that specific number, I do not know. But by operation of math, the testimony in the record, based on the fact that the court allowed all the parole evidence in, showed over $207,000 loaned by the appellant to the appellee during the course of their marriage. The appellee certainly had made payments on these various loans over the course of the marriage, and he submitted Exhibit 2, which is a chart of these payments. The problem is, though, if you take all the payments he made from the earliest up until the date of the marital dissolution agreement, and again, you do the math, he paid $90,900 on over $200,000 worth of loans he took from his wife. So if the appellee is true or correct, that we can go back and consider all the pre-MDA negotiations and consider everything, that actually disfavors the appellee, because then he would owe, by operation of math, the sum of $116,000 plus. I don't think that's a position he wants to hold.
Mr.
And
Creech, let me ask you, is there proof in the record from which we could determine how much was paid after the MDA was entered into?
yes, the chart exhibited or entered into the record shows both payments made pre-MDA
No,
and
no, I'm not interested in pre-MDA. The payments made as per the MDA, which was supposed to start in May of that year. Do we know what that amount is?
yes, to the extent that the chart he submitted also includes post-MDA payments, and there was testimony to that effect, Your Honor.
And those amounts are agreed to.
I believe all the payments made post-MDA are agreed to, Your Honor, yes.
Okay, all right.
And I tender the floor because my time is up.
Thank you, Mr. Creech. Mr. Darnell.
Thank you, Your Honor, for giving me the opportunity to speak here today in regards to this interesting case. This is all about an ambiguity. Is there an ambiguity in this agreement? And I'll be the first to say that everything that the judge allowed in, the premise behind the case in and of itself is clause section 9 ambiguous. And it's ambiguous. The judge found some of the evidence that showed it was ambiguous was essentially the fact that the singular term loan was used. So he went further and used the extrinsic evidence to try to determine what did they mean by that. And I think our argument was, of course, was that the term in section 9, the very first sentence, is not clear on its face what it means. First looking at it, you might say, well, okay, we have it says husband acknowledges he owes wife the sum of $100,000 for a personal loan wife made to husband during the marriage. First, it identifies a loan. It identifies there was an amount to the loan. Then it goes further and gives these specific provisions of $2,500 per month. And then it also, at the very end of that paragraph, says wife agrees to waive the previously agreed upon 10% interest rate. So we have elements here of an amount that was owed for something. We know there was a note. We know it was during the marriage. We know there was a 10% interest rate on that note. It is in the singular. The court was confused because we were introducing evidence essentially of payments made back to a loan during the marriage that had payments that were almost identical to what they put in this particular provision. And
Darnell, I don't really understand why your client would have been confused. From looking at the transcript, there is no combination of loans that equals exactly $100,000. There's a $92,000 loan. There's a $75,000 loan. There's a $20,000 loan. There's a $20,000 loan. No two comes up to be $100,000. Why would your client have been confused about what he owed at the time that he signed the MDA? Whether it says a loan or the balance of the loan, it's clear from reading the language in the MDA that at that time he owed $100,000 and that he was going to pay that at the rate of $2,500 a month. Why would he be confused about that?
Well, he was confused, and he tells that in his own testimony. The very first statements that came out of his mouth upon examination by counsel was he said basically, listen, I told you when I'm signing this agreement, I'm getting ready to go to China. We'll work out the amount when we get back. He says
we know that doesn't matter what he said orally. We just look at the agreement that he signed, right?
That's correct. But your question was, well, why would your client be confused? He said it himself. He says he thought he was paying on a loan for $100,000 that was taken out during the marriage, and that's what he continued to pay on by agreeing to the $2,500.
Well, I'm confused about why he would say he thought that, because there was never a $100,000 loan, right?
Well, it depends on how you look at that. On page 258, he testified he thought he was paying on a $95,000 note that had been taken out during the marriage. If
Well,
you
what
add
you
it
just said, that he thought he was paying a $100,000 loan.
it was not equal to $100,000. That's correct, Your Honor. Matter of fact, there's not a single note that anybody put into evidence here. We didn't have the notes to put them into evidence, and we certainly would have. Counsel brought them up and asked them orally to his client about those notes, and my client never showed them to him, never saw them. But regardless, yes, both parties testified to several different amounts. You're correct. I mean, these were notes that dated back to 2008, 9, and 10 that came up in the evidence. I'm not even certain which ones were during the marriage, other than the $92,000 note that was mentioned by counsel earlier. In my client's testimony, he thought he was paying on the $95,000 note. I think that was the note he's referring to, but I didn't clarify that through his testimony. Now, if you add the interest rate that was going on the note, which was 10%, both parties admitted that, then it would be around $100,000 note, not a $100,000 balance on a note. And that's what the judge, I think, in this particular case saw the ambiguity when the testimony being elicited by my client and the plaintiff, by the way, was that essentially these payments were $2,500. My clients had just paid a January, February, and March payment of $2,500 to her prior to entering into the MDA. That tells
Mr. Darnell, let me ask you a question. And it's sort of along the same lines as Judge Armstrong. I read this paragraph. I do not see anything ambiguous about it. Now, it may be wrong. It may be inaccurate, but there's nothing ambiguous about it. The issue is not at least in my way of thinking, it's not that it's ambiguous. If you wanted to reform it and have it say something else, then I can understand where you might want to do that. But I'm really struggling with the ambiguity here. Can you explain that?
Well, I think that the definition of ambiguity essentially is a misunderstanding. I think the planner's
I don't think that's correct. I think you read what it says, and I think the law is crystal clear that if you can read something and understand what it says, and it plainly says what it says. Now, whether it's right or not, that's a different issue. But being ambiguous is something that I'm really struggling with to ascertain why the court found this paragraph ambiguous.
Well, I think he looked at it that they could be interpreted as more ways than one. My client said,
tell me how you can interpret this language. Husband acknowledged he owes wife the sum of $100,000 for a personal loan wife made to husband during the marriage. What's ambiguous about that?
Well, I think it's ambiguous that owes $100,000 referring to a previous loan.
But the only way it becomes ambiguous is the consideration of parole evidence. And the only way you consider parole evidence is for the language to be ambiguous in the beginning. It's sort of like which comes first, the chicken or the egg. Here, there is no ambiguity, so hence there should be no parole evidence. Now, I may be missing this totally, but it's a difference between reformation and ambiguity.
Well, is reformation okay? I mean, that would be the question here. I mean, according to law of the case law, I think
a totally different theory here.
It's a different issue, but the judge decided on the ambiguity issue, and I'm just arguing. He said he thought it was ambiguous essentially because I think he interpreted it to have two different meanings. And when my client testified to the intention that he understood it to mean, hey, yeah, I owe the balance of what I owed her, and I'm going to continue to pay it, which he did. Now, extrinsic evidence, as far as parole evidence, can be introduced to, for instance, not vary a contract or supplement it, but to explain it. I guess trying to give an example of that, to put it into context. In other words, the context in this particular case was there was a loan. There was a previous loan. They were incorporating it into this agreement. The wording was horrible. My client was unrepresented, and he understood it to simply mean an amount that was owed of $100,000, roughly $100,000. That goes to the generality of it here. I think neither party really put a whole lot of thought into that amount when they agreed to it, but nevertheless, he interpreted it to mean that particular loan, and he was continued to pay on that loan. Now, as far as the any other issues in the case, there has been no issue or anything mentioned about the contempt action in and of itself, him not finding him in contempt. We would stand on our brief on that particular issue. I think the facts were clear. The judge, I think, had discretion to believe my client or not believe my client in reference to his financial situation. He went through a turbulent, terrible time through his import-export business, trying to find suppliers. COVID hit, became even worse. And by the time of the hearing, he was living off limited money from his own father. So we do think the court was correct in finding that he was not in contempt in reference to his non-payment. The question is going to be, if this case goes back or your honors reverse it, what's going to happen? Would it be remanded for the judge to make another finding without excluding all those previous payments and determine what the current payoff on the loan is now, and then her get a judgment for that amount? I don't know. That's something for your honors to decide. But as far as the any other issues associated with the ambiguity in and of itself, my client's understanding of the contract, I think it's pretty self-explanatory what I put in the brief in and of itself. Any other questions?
Let me ask you, Mr. Darnell, at the time that the contempt was filed, were the payments being made? I'm somewhat confused about this. I got the impression from reading the briefs that there may have been an automatic withdrawal where that $2,500 was coming out his account. And then in addition, pursuant to the temporary order that was entered, he was paying another $1,000 a month. Is that true or not?
I can clarify that for you. The January, February, and March payments were not contradicted. Everybody agrees that she actually said that she received the payments.
I'm sorry, say that again.
The January, February, and March payments of 2019 were received by her. So we're talking about April was the month that the MDA was entered and the divorce was done. So the first payment was due in May.
In May.
In May, June, and July, we entered into an agreement to pay the $1,000 a month for 6 months, with through September or something of that nature. And then, but during that period of time, an automatic draft kicked back in at my client's bank, and $2,500 was taken out, I believe, 3 consecutive months. So in other words, he was double paying the $1,000 plus the $2,500. And I think that's what your honor is referring to.
Right. So there was no automatic. So there was no automatic draft in May, June, and July. Is that right? It didn't kick in until later.
Until later, that's correct.
So at the time of the contempt, he had not made some payments that were required under the MDA. Is that right?
That's
all right.
Correct.
Anything further, Mr. Darnell?
I think that's all I have.
All right. Thank you, sir. We'll hear from appellant's rebuttal.
First off, as to Judge Stafford's question, I was able to go back through the record. It's page 259 in the record, or page 26 of the transcript, where the attorney representing the appellant at the trial court level objected on relevance by arguing that the language of the MDA says it supersedes all prior agreements. And that's where your honor may find that if you want to. Just a couple points as to Judge Armstrong's point. The case of Lee versus Ridenauer, a 2010 case I cited, is a good example of the point that I think the justices here are making. That is, in that case, a father and a son entered a loan in both names in 2003, and then they entered a second loan, which modified the first, and then there was a subsequent default. And in order to get out of their obligations, they were trying to argue that there was some inconsistencies and there were these grammar errors that they referred to both a singular and a plural in terms of who was the grantor of the real property. There was a singular subject with a plural verb, that the persons who were actually buying the real estate were listed grantor in one place. So there was a number of errors in those documents, and the Court of Appeals basically said, while not perfect, we understand what's going on here. There's a clear enough intent of the parties' dealings and what is to be determined by this agreement, and it is enforceable. And I think this is on par and within the four corners of that Lee versus Ridenhour case, where while not perfect, we all understand what's going on. They compromised a series of debts into one number. Now, Mr. Darnell asked what the court should do if reversed and remanded. And the first thing I would say is to determine attorney fees. Cited the case of Eberbach versus Eberbach, 2017 Supreme Court case, which clearly defines in Tennessee that if the contract between the parties says there's attorney fees to be awarded if enforcement action is brought, the trial court does not have discretion to simply overlook that. And in this case, you'll find in the record, the trial court specifically said, he's not been paying, this is the amount, and I'm not awarding attorney fees because the contract is ambiguous. Clearly said that. So I think that's just outright error just right out of the box, because if you read the brief of the appellee in 3 places, he tells you about how he didn't comply with the agreement. Your Honors has to realize he stopped payment on the first 2 checks after the MDA was signed. So he signed this agreement and he was in default almost immediately. We brought suit. We got this temporary order to get some cash flow to our client, but he's been in a state of default for months, if not years at this point.
Let me ask you, Mr. Creech, at the time of the hearing on the contempt, considering the restart of the automatic drafting and the extra $1,000 a month, was he in the arrears at the time of the hearing?
Well, Your Honor, I believe so, but I don't want to, math is not my strong point. I think the record and the payments themselves have never been disputed. So the record will show what the balance was. I do know this. I do know that the trial court got the number wrong because he counted pre-MDA payments. So whatever the payments were from thereafter, and I credit Mr. Darnell's explanation that his client made a mistake by having an order to pay one thing and paid a different amount, but all the payments he made were correct. Now, whether that caught him up, I don't know, but he was certainly behind. He was in default. We had to bring suit, and that triggers the attorney fee provision.
Well, you said he was certainly behind, but then earlier you said you didn't really know what the total was. How did you know if he was behind if you don't know what the totals are?
Well, he was behind at the time of the filing of the motion to enforce.
Okay.
We had to incur attorney time to negotiate a temporary agreement to get to the final hearing, Your Honor.
Okay.
And after my brief, Justice Golden delivered the opinion out of the Western District in the case of Batchelor versus Batchelor just this year, a similar issue where the court reaffirmed if there's an MDA contract and it has non-compliance and an attorney fee provision, the court does not have discretion. It's just a matter of determining what's a reasonable fee. So I would ask this court to instruct the trial court to award reasonable attorney fees both for the hearing and the appeal. And my time is up unless Your Honors have any questions over time.
Hearing no further questions, thank you, Mr. Creech and Mr. Darnell, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 11:30 a.m.
Thank you. And counsel, you may exit the Zoom meeting.
Thank you.